The government has implemented many interventions in order to curb its volume of litigation. Most recently, last month in October, the Ministry of Law and Justice set up a live cases dashboard under its LIM system to monitor the ongoing cases on a real-time basis. These policy interventions show the government's inclination towards improving ease of doing business for the firms with the government and an increased appetite to settle its long-pending contractual dues. But what forms the basis for these interventions? Three major ideas shape the discourse predominantly when it comes to government litigation. Firstly, that the government is unusually litigious when it comes to contract performance and dues. Second, there is a large volume of litigation that the government is party to. And thirdly, it delays the processes at courts, adding to an already overburdened judicial system. We use data of 8 years from two high courts, Bombay and Delhi, to test these claims. For this purpose, we use disputes arising from the government's commercial activities, that is, where the state acts as an economic agent engaging in contractual activities and procurement-related activities. For instance, our dataset would include arbitration cases which pertains to appointment of arbitrator or challenging of an arbitral award. Also, execution cases where the state is trying to enforce or is being sued to enforce a court decree or an arbitral award. Similarly, commercial suits where there is a contract enforcement required either by or against the government. For the purpose of our study, we do not include writ petitions, for instance, though there may be many instances where parties use writ petition as a tool to enforce performance of contracts by the government because writ petitions usually see quicker disposals in courts. However, in these cases, it is difficult to distinguish between writ petitions for enforcing contractual claims versus writ petitions for enforcing fundamental rights. So we leave writ petitions out of our study. Moving on to our findings. Our first finding pertains to the volume of litigation at these courts that can be attributed to the government. We find that at the Bombay High Court, less than 10%, that is, only 8.5% of commercial disputes can be attributed to the government. At the Delhi High Court, this number is slightly larger at 13.5%. This is a lower fraction compared to the government's relative expenditure on its procurement activities. From the court's perspective, any reform aimed at reducing the court's caseload by reducing government litigation is unlikely to make a difference because this is such a low fraction compared with the entire caseload of the court. However, from the government's perspective, this could also mean that only a very few large firms who are capable of financing lengthy appeals and going against the counterparty with a superior bargaining power are actually coming to court with disputes. Our second finding investigate in what proportion of these cases is the government initiating the cases versus in what proportion of this case is the government defending itself. We find that in the Bombay High Court, less than 20% of the cases are actually filed by the government. In the Delhi High Court, this number is at 40%. So what does this mean? It means that more often than not, the government is being dragged to court than the government being litigious by itself when it comes to contract. So when the government is a respondent to a case, that is, when the government is being accused of breach of a contract, the underlying problem likely is in non-performance of contract, weak payment discipline, or lack of a strong grievance redressal mechanism within the government departments and procuring agency to resolve disputes before they go to court. Finally, we examine, once a matter reaches the court, how long does government cases take when compared with non-government cases? That is, whether government stalls the processes and procedures in the court, does the government take more adjournments, does the government not appear in court on time and prolong the disputes in court. We find that, irrespective of the court, in fact, more proportion of government cases get disposed of within 1 year than non-government cases. Yes, there are a long tail of pending cases that do get stuck in court as time progresses, but these are likely to be high-value, complex disputes that do take a long time in court to get resolved. Now, how does evidence on government's volume of litigation and probability of resolution in courts have a bearing on firms and government reforms? For firms doing business with the government, such information hold insights for the firms to examine and estimate the resources that would be required in order to pursue litigation against the government at courts. Based on this, they can make decisions as to whether they want to settle prior, or they can also factor in these costs within their contracts. For policymakers, real gains can be achieved by focusing reforms upstream on better contract design, building state capacity to monitor performance of contracts, systems to release payments on time, and downstream set up adequate case flow management systems and information system in order to make settlement decisions on time. Thank you.